Hi guys, it's Tracey from Cape Etc. and I'm here to tell you more about the Breda trial. Henri has been charged with the murder of his mother, Teresa, his father, Martin, and his brother, Rudy, and he's been charged with the attempted murder of his sister, Marilee. The case has been closed in terms of leading evidence as well as legal argument. So I actually have a printout in front of me of the amount of argument that was led, and in total about 320 pages of argument, which I am going to try and summarize for you. So I won't deal with each and every aspect as thoroughly as they did in court. We've produced a graphic and we've got the scales of justice because as from the very start of this trial, I've told you that it really is going to be a balancing of the two versions and deciding which side is heavier. So on the state side, I've listed what I believe to be the strongest point. So the first point on the state side is the fact that Henri was found alone on the scene. This is obviously a strong point. There was nobody else found on the scene and he was there, the only one that survived the attacks without having similar wounds to the rest of his family. Then the self-inflicted wounds. Now, I think this is the strongest point for the state. So the self-inflicted wounds evidence, which I have dealt with in detail in my videos, which are on the Cape Etc. website. And if you want more detail on that, you can go and look at those links. In summary, there was two experts that testified for the state, and that was Dr. Timmensma and Professor Dempers. And they both supported the version that it was most probably the case that Henri's wounds were self-inflicted. Now, Henri had wounds on his chest and on his left arm, but the biggest one was in his stomach. And he then said he removed the knife from his stomach, and that's why his fingerprint was on the knife. And that stab wound is now being put in dispute by the defense because the expert said there's a possibility that that was not self-inflicted, and the state quite rightly said that in the context of all of the wounds that Henri had, given his version that there was an altercation between himself and the alleged attacker, as well as the nature of the wounds being very parallel and straight. If there was a fight, a life and death fight, there would have been movement in the wounds that were allegedly made during this altercation. So both experts believe that it's highly probable that those wounds were self-inflicted. The defense never led any experts to counter what the state's experts said about the self-inflicted wounds. The defense actually had an expert, which was Dr. Perumal, who was a pathologist. I think that the judge could draw a negative inference from the fact that they had an expert in court. They had, to some extent, consulted with him on the self-inflicted wounds because he actually showed them a reference in a textbook. And yet they elected not to call him as an expert, to at least assist the court in a matter where there's incriminating evidence and they only have the state expert's version. What the defense has said in response to that is that, and this is when they're relying on the law, is that when an expert witness gives evidence in court and the accused gives evidence in court, if the accused's version is reasonably possibly true, then even if it contradicts what the expert says, then you actually have to accept the accused's version. So if Judge Desai thinks that Henri's version of having an altercation with the attacker is reasonably possibly true, then he has to exclude the expert's conclusions on the fact that those were most probably self-inflicted wounds. Then the third strong point that the state has is the security of the estate. So we heard loads of evidence about the security in the estate, about how there was constant patrols, there was cameras all over the estate, there was access control, the perimeter fencing was checked that night, there was no damage, there was no evidence before the court that there was any intrusion that night. The defense argument against the security is that there is a report that an alarm went off on the fence at 3:37 a.m. that morning, which would be consistent with shortly before the murders took place based on the telephone call evidence. And their argument is that objectively, and there is a fact in front of the court that an alarm went off. But that's really as far as it goes in terms of the perimeter, and Judge Desai is going to have to look at that holistically and make a decision on whether or not it's reasonably possible that two intruders could have entered the estate undetected and exited the estate undetected. There is no evidence of an intruder with regards to DNA, firstly, which is also another very important point on the defence's side. The evidence that there was no foreign DNA found on the scene. Insofar as fingerprints, all the fingerprints that were lifted from the scene were verified to be those of family members, and they were matched to the state's database, and they didn't match any suspects on the database. The shoe prints, there was no unidentified shoe prints. There was also no fingerprints on the boundary wall, but then the defense does say that the intruder was wearing gloves, so that is a reasonable explanation. There was also no signs of a break-in in the Van Breda house. There is also no signs of the attackers having fled. On Henri's version, the attackers fled out the kitchen door and along that boundary wall, and they must have jumped over that wall, exited the premises from that side. So there are two tiny spots of blood. I would say they were no bigger than a centimetre, right next to each other, so they probably came from the same source. The blood is Rudy's blood, so the state's evidence is that this blood most likely came out of the window when the blood shedding event happened with Rudy. So when Rudy was attacked, that this little drop of blood could have been flung out of the window. The state's blood expert did concede that it could be blood that came from an object, but if you consider the nature of these attacks and how much blood was shed, and that an accused immediately after attacking this family two perpetrators ran out of the house with something dripping of blood, then there would be more blood trails running down the stairs and outside the kitchen door, and if they then climbed over the wall, that there would have, regardless of whether they had gloves on, that there would have been more blood. So Judge Desai did also note during argument that it was strange that there wasn't a lot of blood at the bottom of the stairs. All of the blood was at the top, and there wasn't any trail going down the stairs, and you would have thought that there would have been had an attacker fled the scene. Then also the obvious that there was no valuables taken from the house. There was laptops, there was handbags, there was cash in the handbags lying on the tables. And then the other point, which I thought was well raised by the state, was the location and the severity of the attacks. And all of the attacks were located in or outside the boys' room. Judge Desai used the words that this was almost a frenzy, and the state is arguing that that means that there was probably a personal relationship because of how frenzied the attacks were, and particularly Rudy, who was apparently attacked the worst. The state argues that everybody had been sleeping. They were all in their pajamas, and they were all drawn towards the room where the attacks were happened. It's unusual that nobody tried to hide or go and seek help. So for instance, Marley was very young at the time, and if she had heard an intruder or even seen an intruder, it's unlikely that she would have ran towards where the danger was. It's more likely that she would have hidden or gone to find help. And perhaps likewise for Teresa, the state thinks that the victims knew the attacker. Then the fifth point on the state's case is that 2 hour and 40-minute time lapse between when the murders were committed and then the time that he made the phone call to the emergency services. The state's case is that Henri moved Rudy off of the bed, he moved the duvet and made various attempts to stage a scene to make it look as if he didn't commit the crimes. This included hitting the axe into the wall, which the state says was a controlled movement, that he possibly showered because Rudy's DNA, blood DNA, and Henri's blood DNA was found in the shower. And the fact that his fingerprint wasn't on the axe means that he possibly wiped the axe. And also during this time, Marley was alive. The sixth point for the state is that the axe and the knife came from within the house. The seventh point is the phone call. So we all heard that 23-minute long phone call. The state's argument is that Henri was calm, he was logical, he was strategical in his thinking during that call, and he also smoked 3 cigarettes, and his sister was upstairs and still alive, and he didn't assist her. The 8th point is the contrasting injuries that Henri had. So this ties in with self-inflicted wounds. It's the contrast between the injuries he sustained and those that the family members sustained. They all had head wounds that were severe, and Marilee didn't survive because her attacker intended for her to survive. That was just a miracle. Henri's statement is actually a point on both sides, and they both have different arguments. The point in favor of the state is that the morning that he gave it is consistent with his version that there was intruders, but the state is saying that since giving that statement to the police, he's now altered or added detail where he'd previously omitted detail, and that his reason for doing so is that he's only really added where evidence was incriminating. So the first being that he now had a different timeline for when the family members went to bed. He introduces the Star Trek movie that he watched with his brother and his father, and this is to give a reason for the neighbor hearing the argument. Then the second is that he had blood spatter on his shorts from Rudy and Martin's blood. And in his initial statement, the state argues that he said he was inside the bathroom when they were attacked, which means he wouldn't have had the blood spatter on his shorts. The state's version is that he changed his version to say that he was actually inside the room when they were attacked, and that explains why he had the blood spatter. And then the third point, he never mentioned 2 intruders to the police, he only mentioned 1. There's no evidence of Henri having sought help. He didn't run to a neighbor's house. In fact, he didn't even phone the security. The emergency numbers were on the fridge. He knew that his sister was alive. And then that ties in with the next point, which is aiding his family. And Judge Desai actually noted, he said, you know, you've got to think it's a close-knit family, that's the evidence, that an intruder has come in and they're attacking the family. You don't stand and simply do nothing. One, there's an instinct to protect, and there's also an instinct to aid after the fact. So I'm not sure that Judge Desai is pleased with Henri's reasoning. Also, the fact that he heard Rudy gurgling, he knew he was alive on his version, although the state said that Rudy couldn't have survived the attack. He heard Marilee, he knew she was alive, and he didn't do anything to help them medically. The 12th point is the blood in the shower. This is quite a strong point for the state, so it also ties in with the DNA evidence which the defense has raised. It was Henri and Rudy's blood that was in the shower. Henri actually testified in court and said, well, Rudy and I used to shave in the shower, so, you know, we probably cut ourselves and that's why there was blood. And the state argued this means that both of them showered, both of them cut themselves, and it wasn't cleaned in the time before the attacks. And then the 13th point is the argument heard by the neighbor. This is positive for the state. I think it gives a little bit of context and motive to the reasons that Henri might have committed the crimes, but motive is not important in South African law. So Judge Desai is going to give his judgment on the 23rd of April. So we've got just over 2 months to wait until we hear what Henri's fate is.